So there will be a record of this so that people will be able to look back on it if they so choose. Thank you very much. It is a great honor to be asked to address you here on this topic. I'm sorry that I cannot be in Yerevan with you. I've never been. I have to say Armenia has been in my consciousness since childhood because I was a chess player growing up, and the world chess champion in the 1960s, some of you may know, was Tigran Petrosian. And he was my favorite chess player as I was learning to play chess in the 1970s. Armenia has that sort of role in my consciousness, but also, of course, many events that have taken place historically. I'm here today to talk with you about my work on recognition of governments, which has been really a focal point of my career. And I started getting into this about 35 years ago. And interestingly, at that time, among international lawyers, the idea was that recognition of governments was a peripheral topic, that this was primarily a matter of politics, not of law, that states accepted governments as they found them. In the international system, states were represented by whoever was sort of as a kind of realpolitik matter in a position to represent those states in the international system. And recognition was associated with either the entering into formal diplomatic relations or the issuance of declarations of recognition or certificates of recognition directed at domestic courts, but really did not have anything to do with the essence of the representation of the state in the international system. And what I noticed at the period right in the start of the so-called post-Cold War era was that actually this was entirely a mistake, that recognition of governments was essential to the operation of the international system, and that this was because the legitimacy of a government could be called into question, and that was not simply political legitimacy, but a question of legal validity in terms of the role of the government with respect to the prerogatives of the underlying state, and particularly the right of the state against intervention from outside in the internal affairs of the state. And so I began writing about this right from the moment that I returned to graduate school after law practice in the early 1990s, and ultimately produced, after my PhD dissertation, the book Governmental Illegitimacy in International Law from 1999. So if you ever want 430 pages on the question of when is a government not a government, that is the source that I can refer you to for better or worse. But I will try to give you some highlights of the idea about recognition of governments here and point out to you what some of the fault lines have been in the discourse on this question. And I have given you this two-sided handout that is my sort of trademark way of presenting materials to people and groups rather than relying very heavily on projection of outlines. So hopefully you all have that. However, I will do a little screen sharing just to try to introduce this a bit. So you have what I referred to at the start here as foundational premises of the international legal order. And the first thing to recognize is that when we speak of states in the international system, we are not speaking about governmental apparatuses. We are speaking, indeed, not really about empirical qualities at all. We're speaking about a kind of conceptual framework here. States are understood as bearers of sovereignty in the international system, and these are territorially based political communities. And so we immediately find ourselves in the difficulty of trying to figure out what entities have the status of statehood or not in the international system. And this is a whole topic unto itself that I won't belabor at great length on this occasion, but I will allude to some of the controversies surrounding this. But you can't really tell what counts as a state by simply looking at a map or discerning something about territory. What you need to discern is how the international community has set about to assign a package of rights, obligations, powers, and immunities to a political community that is encompassed by a particular set of territorial boundaries acknowledged by the international system. The bearer of this set of legal qualities is called the state, and the state therefore exercises what's called sovereignty. Sovereignty itself is a puzzle as a term. Sovereignty refers to the idea of an uncommanded commander. And that's not quite what sovereignty means in the international system, precisely because what we have is an international system based on the sovereign equality of states. And to say that states are sovereign equals with one another is already to say that sovereignty of one state is limited by the equal sovereignty of the others, and is actually further to say that the sovereignty of each state is limited by the fundamental purposes and principles of the scheme that brings together states in relation of sovereign equality. So sovereignty is not as crass as the idea of an uncommanded commander as a practical matter. It is nonetheless what I've referred to as the bearer of the presumptive last word on public order in the territory, on what counts as public order in the territory. And so we think about sovereignty in the international system in terms of a kind of horizontal legal order in which states are self-sufficient sources of authority, but bound together in a system with other states. There is, as you probably know, a famous piece of rhetoric in the international system from the 1920s in the case of the SS Lotus, where the Permanent Court of International Justice said that restrictions on the independence of states cannot be presumed, which is a kind of backhanded reference to the idea of sovereignty, but it contains a fundamental ambiguity because the independence of state could be understood as freedom or as exclusivity of territorial control. And I would argue that actually, particularly as the 20th century progressed, it became clearer that sovereignty in the international legal order as we've come to know it is primarily associated with exclusivity of territorial control. And that persists subject to particular narrow exceptions, and especially the capacity of the Security Council in the United Nations to declare a threat to the peace or breach of the peace or act of aggression, which then triggers a set of special powers of the Security Council that can override the sovereignty of the state. However, there's a very strong default position, and that is that there needs not only to be 9 out of 15 states agreeing to the Chapter 7 resolution, but also that there be no vetoes from any of the permanent 5 members. So the default position is sovereign equality with this override provision in the United Nations Charter. States, as I say, are the bearers of rights, obligations, powers, and immunities. Governments are the institutions that assert rights, incur obligations, exercise powers, confer immunities on behalf of the sovereign entity. And so it becomes actually crucial to identify who is in the position of representing the state for these legal purposes, because otherwise we have no idea actually how international law is going to relate to this package of rights, obligations, powers, and immunities. And that's particularly the case where more than one government steps forward to assert that it represents the state. And that, of course, pertains very directly to the topic of most interest to you, which is this question of coups or perhaps insurrections or other unconstitutional changes of government, where there is a government that asserts effective control on the ground, effectively representing the state simply in terms of creating facts, but there is another government that claims some sort of constitutional mandate, perhaps organized in exile, and perhaps gaining recognition of one form or other from other states or even international organizations. And so figuring out who is the government of a state is going to be critical in determining how rights, obligations, powers, and immunities in the system operate. Now, in talking about statehood, we will just quickly discuss some of the basics here. It's impossible to talk about statehood without recounting this banal language from the Montevideo Convention on the Rights and Duties of States, a treaty that as a treaty in itself is not terribly important. It only was a treaty among Latin American states. And it is not very much referred to as a source of treaty rights nowadays. It's been superseded largely by other instruments, but it embodies this particular definition of a state that is constantly referred to as though it tells you something. And so what it tells you supposedly is that a state has these four components: a permanent population, a defined territory, a government, otherwise thought to be a government in effective control, and the capacity to enter into relations with other states. This actually tells you nothing that you need to know about statehood controversies, because all putative states have these characteristics in one form or other, but the real question goes deeper than this. You would think from the way that this is typically articulated that a state is any permanent population within a defined territory that is effectively represented by an independent government. And that turns out not to be the case, that there are many entities which for one way or other are disqualified from counting as states. You think of a place like Somaliland, for example, the northwestern part of the state of Somalia. It has been effectively self-governing for basically as long as I've been studying these topics, for about 35 years. And yet it is not recognized as a state in the international system. And that is because it is thought to run afoul against this rule against premature recognition, which is kind of circular in definition. Hersch Lauterpacht, the great theorist of international recognition in the post-World War II era, talked about the idea of recognition being premature if it is conferred before the central government has lost all hope or abandoned all effort to reassert its dominion. But the reality of it is that we don't know what counts as maturity of these circumstances until the international community itself has collectively passed some sort of judgment on this question. And so premature recognition really doesn't tell us very much about that. The other major area where there is a refusal to take account of rights, obligations, powers, and immunities on behalf of an entity of this sort is where the existence of the entity is seen as an artifact of an unlawful external use of force. So that would be, for example, in cases like Abkhazia and South Ossetia within Georgia, or now with Donetsk and Luhansk within Ukraine. These are unlawfully created entities because they were established through the unlawful use of force by a foreign power, and therefore they are denied recognition. So you have a complex set of circumstances where you're trying to figure out what counts as a state. Decolonization has given rise to the emergence of states that have not fulfilled the criteria suggested by the Montevideo Convention. So the Montevideo Convention criteria are not necessary conditions, but they're also, as I mentioned, not sufficient criteria either. Generally speaking, there is a tremendous bias in favor of the territorial status quo. So it is very difficult to establish the existence of a new state unless the government of the state that has previously controlled the territory has conceded the independence of the state. That is to say, outside of the decolonization context, which is very different. The major area of exceptions to this had to do with the dissolution of the Socialist Federal Republic of Yugoslavia in the 1990s, and that generated a whole series of novel questions that were addressed in all sorts of complicated ways, and that's a whole tangential topic that I won't get into, although if people have questions about it, we could talk about it. In general, recognition is a subject of controversy as an aspect of legal validity because there are these two different ways of thinking about recognition. One is that recognition is merely declaratory of the status of the state. And therefore, statehood is an objective matter based on the application of legal doctrine to facts. The problem with the declaratory theory, however, is that, as in the case like Somaliland and various other circumstances, it really isn't true that the international system will acknowledge rights, obligations, powers, and immunities of statehood based on objective criteria, irrespective of international reactions. And this is the problem that if a tree falls in the forest and no one hears it, does it make a sound? If indeed a state fulfills all of the supposed legal criteria, or an entity fulfills all the supposed legal criteria of statehood, but no one treats it as though it has those legal qualities, then it's really quite useless to say that the state has those legal qualities. One might, for example, one scholar made the argument that Tibet should be understood as a state in this sense and be the bearer of rights, obligations, powers, and immunities in the international system. But whatever one might think of the objective case for that, it is clear that Tibet does not function in that way in the international system, and therefore is quite useless to speak in those terms. So what's left is some version of a constitutive theory of statehood, that statehood is constituted by existing states' acknowledgement of the status. This is formally rejected in almost all of the literature, and yet the truth of it in some form seems self-evident. The reason why it's rejected is because recognition is typically defined in these terms as a political expression of recognition, and mere political expressions of recognition by individual states or even by groups of states would not count for this purpose of establishing the legal validity of an entity's claims. But if there is a collective opinio juris, if states collectively can be seen to have manifested a legal judgment with respect to this question and have established that the state exists in the sense that the entity bears the rights, obligations, powers, and immunities distinctively held by states, then it appears irrefutable that the state exists. A similar set of questions applies to governments. As I mentioned before, when recognition of governments was seen as a peripheral question, the idea was that these declarations of recognition really were irrelevant in legal terms, and indeed that there was something presumptuous about foreign states making judgments about who the legitimate government of the state might be, and therefore some states, in fact, sought to abolish recognition in the sense of abolishing the practice of making declarations of this sort. And of course, the existence of full diplomatic relations does not in itself have any direct impact on the question of a government status. A government may be denied full diplomatic relations with other countries, and yet might still be acknowledged to be the entity, to be the institution with standing, with legal capacity to assert rights, incur obligations, confer immunities, exercise powers on behalf of the state. So the real question is, who does the international system think, as a matter of legal judgment, actually bears this capacity? We saw this play out in a very divided way in the case of Venezuela after the 2018 elections, where Nicolas Maduro was reelected president in Venezuela in a process that was boycotted by most of the opposition. And the opposition, which dominated the National Assembly, asserted that the presidency was vacant and asserted, therefore, that the president of the National Assembly could take control under the terms of the Venezuelan Constitution and be recognized as the interim president of Venezuela. And so you had the Maduro government and the Guaido government, which contested the question of representation of Venezuela in the international system. In fact, by a relatively narrow margin, the Organization of American States sided with the Guaido government, such as it was, and de-recognized the government of Nicolas Maduro and sought to confer upon the opposition-dominated government the ability to exercise the rights of the Venezuelan state. And this indeed was accepted by about 60 countries around the world, and it had legal impact because the Guaido government was able to assert ownership in some cases over Venezuelan state assets that were held in foreign countries on the ground that they represented the legitimate government of Venezuela, notwithstanding the effective government, which remained in the hands of Nicolas Maduro. That issue somewhat melted away in that the Guaido government ended up being dissolved, it having failed to achieve its purposes. Most states continued to recognize the Maduro government, and the United Nations continued to credential the representatives of the Maduro government. So the government in effective control was continued to hold the position for most legal purposes of the bearer of the capacity to assert rights, incur obligations, confer immunities, exercise powers on behalf of Venezuelan sovereignty. This idea of effective control through internal processes is an idea that could be ascribed to two different rationales. One is that it is simply a matter of realpolitik, that states as a practical matter need to deal with whoever is in a position to control territory. And so idealism shouldn't get in the way. We should engage in diplomacy with whoever it is that manifests the capacity to do the things that we need to interact with in the international system. And so that's one way of thinking about the effective control doctrine. But there's another, I think, more important way of understanding the effective control doctrine, and that is as a manifestation of the self-determination of the underlying territorial population in circumstances where we don't have common criteria for establishing who exercises power validly on behalf of the state. That we have, in fact, an ideologically and culturally plural international environment. The touchstones of legitimacy have not been clearly established. It is largely viewed, certainly in much of the world, as being presumptuous for any kind of external actor to seek to be the arbiter of who exercises power legitimately in the state. This is an idea actually that goes back to Thomas Jefferson when he was represented Secretary of State of the United States at the time of the French Revolution, and spoke of the will of the people substantially declared. That is to say that people having acquiesced to a form of government that had been established through internal processes in France. This meant that to respect France as an international actor is to respect the government that emerged from those internal processes, and where the people are heard through their pattern of acquiescence, because it is presumed that people would prefer to be governed, would prefer to be represented in terms of the rights of the political community in the international system, by whoever is able to effectively represent the territorial political community, even if they're tyrants, even if they're people who would be disapproved of by a majority of the population. The majority of the population is not expecting to be rescued by foreigners. It's not expecting that their position is going to be improved by foreign entities making their own determination as to who should represent the rights of the state. Rather, the presumption is going to be that whoever has emerged from internal processes, whether it be bullets or ballots, represents the state in the international system. And we see this playing out particularly in the period of the United Nations Charter, and more specifically in the post-decolonization era, where you have an emergent constituency within the international community that is very concerned about neo-colonialism. That is very concerned that states having emerged from colonialism do not want to be resubjugated through indirect means of interference in the internal affairs of their states. And as you have after the Bandung Conference of 1955 and similar events, starting in the late 1950s and persisting certainly through the period of the Cold War, you have an emergent global South that asserts strongly these kinds of concerns about neocolonialism. And these concerns then are reflected in language that's derived from the language of self-determination. So self-determination proclamations have always said that all peoples have the right to self-determination. By virtue of that right, they choose their political status and freely develop their economic, social, and cultural systems. Well, that then, once those peoples have achieved sovereign independence, the next step is to say that every state has, as in the language of the Friendly Relations Declaration of 1970, which is a gloss on the UN Charter's fundamental principles, every state has an inalienable right to choose its political, economic, social, and cultural systems without interference in any form by another state. No state or group of states has the right to intervene directly or indirectly for any reason whatever in the internal or external affairs of any state. Now, some of this is hyperbole. The external affairs part I never quite understood. The for any reason whatever is a little bit overstated in certain respects. But nonetheless, it represents the insistence of weaker states in the international system, which are have a new role in a divided world where you have a first, second, and third world effectively in the international system, and the liberal democratic West and the revolutionary socialist East struggling for influence within the global South. You have this kind of accord that asserts that the norm of non-intervention is going to be critical here, and therefore this is going to strongly reinforce this effective control doctrine in the name of popular sovereignty, in the name of self-determination of peoples, notwithstanding the fact that there may be no provision for accountability of those who assert this control within states to the underlying territorial population. You have dictatorships that operate in the name of the will of the people, and that is taken by and large at face value. One of the great landmarks of the era then is the International Court of Justice decision in Nicaragua versus the United States, where, among other things, the United States, in supporting counter-revolutionary insurgents inside of Nicaragua to try to overthrow the revolutionary government established in 1979 by the Sandinista Front, the United States at least makes political assertions to the effect that it is seeking to democratize Nicaragua and indeed to hold the government of Nicaragua to agreements that it made to hold free and fair elections in Nicaragua subsequent to the 1979 revolution. The International Court of Justice did not hold that Nicaragua had made any such legally binding commitments and did not hold that they had violated any such commitments, whether legally binding or not. Nicaragua did hold elections in 1984. But the key point that the court makes is that even if these assertions on the part of the United States were correct, they would be legally ineffective, because to hold a state's adherence to any particular governmental doctrine a violation of customary international law would, as the court said, make nonsense of the fundamental principle of state sovereignty on which the whole of international law rests, and the freedom of choice of the political, social, and economic and cultural system of a state. Even were there a legal commitment to a particular form of government, the United States could not invoke the kinds of methods that it was invoking, and certainly not on behalf of the Organization of American States, to which the commitment had supposedly been made, because the Organization of American States itself would not have the capacity to use force to displace a government that had breached its commitment with respect to its internal form of organization. The court says, of its nature, a commitment like this is one of a category which, if violated, cannot justify the use of force against a sovereign state. The interesting thing about that, of course, is that it comes right before the end of the Cold War and a fundamental transformation where the bipolar opposition for the previous 45 years melts away. There is, for the moment at least, dominance by liberal democratic powers. There is an emergence of what's sometimes called global civil society, non-governmental organizations playing a greater role within intergovernmental organizations, seeking to influence the direction of intergovernmental organizations, and a move toward seeking to establish a kind of continuity between the rule of law among states and the rule of law within states, and ascribing to the rule of law within states an essential component of democratic governance. And this is associated with a set of academic works in the early 1990s, particularly a very famous article by Thomas Frank in the American Journal of International Law called The Emerging Right to Democratic Governance. And that's a term that's repeated over and over again in the literature. And it's based upon existing human rights instruments that speak to the idea that the will of the people shall be the basis of the authority of government, but have been interpreted in highly open-textured ways. So the United Nations General Assembly approves in 1948 the Universal Declaration. This includes this Article 21 on the right to political participation. The right to political participation is then repeated in the International Covenant on Civil and Political Rights in Article 25 in 1966, and is repeated in regional human rights instruments in the Americas and in Europe. However, the language of the will of the people being the basis of the authority of government is deleted in the International Covenant on Civil and Political Rights, not really because states don't avow that principle. In fact, the international community, as a general matter, understands, based upon the provisions of Articles 1 and 2 of the UN Charter, that the idea of the sovereign equality of states is based upon the equal rights and self-determination of peoples, and therefore the will of the people is the basis of the authority of government. It's just that there is an open textured understanding as to what counts as a manifestation of the will of the people, and there's no particular formula of free and fair elections that determines the foundations of governmental authority for international legal purposes. There may be a right to participate in government, but that right to participate in government is viewed different ways through different ideological lenses. And during the Cold War, this was seen as simply not simply an open question, but a question that was essentially within the domestic jurisdiction of states. And therefore not going to be a basis for assigning legal status or withdrawing legal status from governmental regimes. But in the wake of the transformation, the end of the socialist regimes in the East, and other kinds of developments in the international system, with proliferation of electoral processes, multi-party electoral processes, often observed by international observers or even supervised by international bodies, you start to move in a different direction. And perhaps the greatest crystallization of this assertion, really in anticipation of these developments, came from Michael Reisman, who was justifying rather a premature instance of this sort of assertion, the U.S. invasion of Panama in 1989. Michael Reisman in 1990 tried to make the argument that the U.S. intervention, military intervention in Panama, was not a violation of Panamanian sovereignty because real Panamanian sovereignty belonged to the people of Panama, who were represented by a government that had been prevented from being seated after being duly elected, and that government had approved of the United States intervention. And what Reisman said was, when the people's confirmed wishes are ignored by a local caudillo or strongman, in this case Manuel Antonio Noriega, a jurist rooted in the late 20th century can hardly say that the invasion by outside forces to remove the caudillo and install the elected government is a violation of national sovereignty. That was very much a minority view in 1990. In fact, it had been repudiated by the international community at the time of the intervention in Panama. The UN General Assembly voted overwhelmingly against that intervention. The United States, Britain, and France had to intervene with vetoes in the Security Council to prevent a Security Council resolution condemning it. But in the coming years, the idea that an elected government should be seen as being able to supplant a government in effective control, where those in effective control had failed to yield to a newly elected government or had seized control unconstitutionally from an elected government. This idea begins to gain ground, and especially inspired, as I say, by the work of Tom Frank and others like my colleague Gregory Fox. And so you start to have a burgeoning literature on the democratic entitlement thesis. And my distillation of that thesis, you see here, is that you have these three basic moves. The first one is to say that the human right to political participation has a determinate content grounded in in liberal democratic institutional practices. We're no longer going to say that a one-party state that tolerates no organized opposition is going to, through some mechanism of popular participation, going to be seen as fulfilling this human right. Rather, we're talking about multi-party elections with freedom of the press, freedom of assembly, all of the kinds of basic procedural inputs to liberal democratic institutional processes, that these are going to exist as a matter of human rights. So that's the first piece. The second piece is that there's a determinate relationship between these mandated participatory mechanisms and the actual exercise of political power. So it's not enough simply to have a consultative body that is freely and fairly elected. What you need to have is a government exercising effective control on the basis of a mandate from a free and fair election. And so reserves of power for unelected elites would be disqualified. And then the third piece of it, following from the first two, going back to our friend Michael Reisman, the sovereign rights of states in the UN system being predicated on principles of human rights and self-determination of peoples cannot be asserted by non-complying governments against measures to implement democratic rights. How far one takes that is not entirely clear, but some have asserted that a government that has been displaced unconstitutionally in violation of a mandate from a free and fair election should be able to call upon foreign forces to intervene and install the legitimate government in power as against the government in effective control through internal processes. And that is a crucial kind of attempted transformation in the terms of international legal order, whether one accepts it or not. So we come down to these basic questions. Do regimes resulting from coups against constitutionally and freely and fairly elected governments have standing to assert the state's rights under UN Charter Articles 2.4 and 2.7? That is to say, no use of force against the territorial integrity and political independence of states in Article 2.4, and no intervention in matters essentially within domestic jurisdiction in Article 2, Paragraph 7. If a government is illegitimate, then does it fail to have the ability to assert the rights? If another government is seen as legitimate, can it invite intervention in order to establish effectivity on the part of those who are deemed to be legitimate and perhaps have a constitutional mandate for legitimacy? This goes to a whole set of questions about intervention by invitation that we could also take up if people are interested. But at least there's a kind of prima facie sense in which anyone who can assert the rights of the state in the international system can actually invite intervention. And therefore, the fundamental question arises of who the government really is. Or is there a government under those circumstances that can be deemed to have a right to invite this intervention? A second question then has to do with how we know whether a government has this set of capacities, putative government. Can manifestations of collective opinio juris, as I mentioned, about a regime standing, as distinct from mere political recognition or non-recognition, affect the regime's capacity to assert the non-intervention right? So it may be that foreign states pay lip service to the idea that the true representatives of the people are those who have been elected, but that might not be a manifestation of opinio juris. The real question is whether states act as though those who lack effective control but nonetheless have the constitutional mandate are deemed as a matter of international law to have standing to assert rights, incur obligations, confer immunities, exercise powers on behalf of the state. And here it seems to me again that this collective opinio juris ultimately really is the judge, because that's what's going to determine what happens in courts of foreign domestic systems or on the part of executive organs of government of foreign states. You're going to have a real impact based upon judgments about who has the capacity to assert rights, incur obligations, confer immunities, and so on. A further question is whether, in advance of these situations, an elected government could bind the state to what's been referred to as a treaty of guarantee. That was what it was called in Cyprus at the time of Cypriot independence, that would permit external uses of forces to uphold constitutional norms as against those who have seized power by other means. And the question is, are these void under the UN Charter, under Article 103, which avoids any obligation which is at odds with the fundamental principles of the UN Charter, or perhaps the question of jus cogens. There are norms that supersede state consent in the international system, generally that are recognized as being subject to no derogation, notwithstanding treaties to the contrary. This remains a kind of open question. There are really very few such treaties that have been explicit about authorizing the use of force, although sometimes that is read in to treaties, and there have been interventions, particularly by the Economic Community of West African States, that have operated on this logic. To wrap up, so that we can go to some questions, I want to explain why these questions are so double-edged, and this has to do with the paradoxes of the relationship between international and domestic legal authority. It is very difficult, even for international lawyers, to fully get their mind around the complexity of the relationship between international and domestic legality. What a lot of international lawyers would want to say is that there is one law, that domestic law is subsumed within international law, and that is supported by the idea that, as we know in international law, a contrary rule of domestic law does not count as a defense to the breach of an international legal obligation. So the fact that you say, well, I can't comply with my treaty obligations because my internal law doesn't let me, the answer to that is, well, then change your internal law, because the domestic law is not a defense to the breach of international legal obligation. And that's correct. However, that's different from saying that the state lacks the last word on what counts as public order in the territory. In fact, a state may breach its international legal obligation and take the consequence. And as a result of that, the same act can be lawful and unlawful simultaneously on coexisting legal planes. That the exercise of the sovereignty of the state may be in breach of an international legal obligation, but it doesn't render that breaching act legally null and void. Certainly not for internal purposes, but often not for international purposes, because there are certain kinds of breaching acts that can create legal facts that the international system needs to acknowledge. So we have a system that is essentially dualist conceptually, that we have an international legal order and a domestic legal order, and they interact with each other in a complex way. And we need to be respectful of the fact that a state can exercise its sovereign power in breach of an obligation without necessarily opening itself up to direct exercises of power to compel compliance. The legal obligation does not imply the licensing of international measures sufficient to compel compliance. It might allow for countermeasures under some circumstances, but countermeasures in international law are, by their nature, highly limited, precisely because of the vigilance on the part of weak states to sustain the sovereign equality of states in the international system, and the suspicion in a horizontal system of law enforcement that what is done supposedly in the name of global legal order is actually done for the sake of parochial interests by those with the power to punish other states. So legal obligations do not necessarily license the exercise of however much power is necessary to compel compliance. And as I say, it does not, the legal obligation does not imply the renunciation of authority to commit a breaching act and take the consequences, unless in some circumstances the international system has a special rule. That could be the case under Chapter 7 of the Charter. It also, in relation to particular acts in international criminal law, can allow for accountability of individuals precisely because the state has not only renounced the practice at issue, but has renounced the authority to immunize the practice. And that's really the foundation of international criminal law. And so there are narrow circumstances in which states don't have the last word, actually, on what counts as public order in the territory because they've ceded it one way or other through international criminal law, but that's highly exceptional. Finally, the point about the international rule of law is the rule of law is about subjecting sovereign authority itself to law. That's how we understand the rule of law generally. The goal for domestic legal systems is to make sovereignty constituted by legal norms. That's really what constitutionalism amounts to, as opposed to merely having a constitution, but actually making the Constitution the last word on the exercise of power in the territory. Seeks to reduce sovereignty to the legal norms that are established in a constitutional order. But it's important to remember that an international rule of law based on the foundational principle of sovereign equality is an accommodation among territorial communities that bear an underlying capacity to overthrow their constituted domestic authority. So this is the difference between the pouvoir constituant and the pouvoir constitué in famous jurisprudential language. You have this, the state is the bearer of the constituent power. The state is the bearer of international legal personality. It has the right to choose its own government. That means the right to unchoose it as well through whatever means. Therefore, the pouvoir constituant has within it the capacity to overthrow constituted domestic authority. The former pertains to the state, the latter pertains merely to the government. That really is, I would say, the default position even now, that stems from the Cold War era and how sovereign equality developed through the United Nations Charter to various instruments pertaining to non-intervention in internal affairs, and especially the Declaration on Friendly Relations in 1970, which was a gloss on that instrument. And as reflected, of course, in the Nicaragua opinion. However, there have been particular instances where the international community has sided with a government that was elected, but was then driven from power or unable to take power as a result of a regime that used force to maintain its effective control as against the constitutional mandate of the elected government. This occurred in Haiti in 1991 to 1994. Ultimately, foreign forces entered Haiti in 1994 to restore the constitutional government. Similarly, Sierra Leone in 1998. In those cases, the case for the elected government being broadly supported was far greater than merely having won an election. There was one could see from a variety of ideological and cultural standpoints the clear sense that those in effective control had been manifestly repudiated by the population. A little more complicated, though, in Cote d'Ivoire and in the Gambia. And there's some sense in which electoral mandates have come to, in particular circumstances, be used to justify external intervention under principles of international law that are consistent with this emerging right to democratic governance. However, those are exceptions and not the rule. I've given a list of some cases here where unconstitutional exercises of power have indeed been kind of broadly tolerated or affirmed by the international community, and the unsettled case of Venezuela maintained. So what we have is a set of conflicts over this question. And this is really the beginning of a much broader conversation about all of this. So With that, I will invite your questions, and I'm happy to stay for as long as anyone has questions. So thank you very much.
Thank you, Professor, very much for a very interesting presentation. So do our participants have any questions? No one?
I should say that I'll provide you with the recording of all of this, and the recording I think will, at least in one version, have subtitles so that you'll have more of an opportunity. I know that I went through a lot of material very quickly here. You'll have an opportunity to digest this more easily on review of it.
And thank you for the lecture. I wanted to ask you one thing. You mentioned in the beginning of the lecture the so-called rule against recognizing fruits of unlawful external use of force.
Yeah.
And I wanted to ask you, where's the borderline between this and simple self-determination that is happening with the use of foreign state means?
Can you get, I'm not sure what you have in mind with the question. Can you explain further?
What I mean is self-determination can happen with means of a foreign state, right?
No, not usually. So for example, if a foreign there is some claim that a group that's seceding from another state has a right of self-determination that is typically not acknowledged by the international system. And if a foreign state decides to intervene in order to make that secession effective, that is typically understood as an unlawful act. So people in Abkhazia may see themselves as having a right to self-determination, but the Russian interference in Abkhazia makes the Abkhaz statehood unlawful from the standpoint of international law. And there are many instances of that nature.
Okay, thank you.
Thank you. Other questions?
I think we have a question online.
Yep.
Anya?
Yeah, thank you very much, Professor. That was a lot, and that was super interesting. I have actually two questions. You mentioned this collective opinion juris as an important factor to come to a conclusion if the state is recognized and government is recognized. So, I mean, does it work for both the recognition of the government and recognition of the state? This collective opinion juris. And the second, what would be, in your opinion, like clear manifestation of such opinion juris? Because sometimes you have different types of legal facts, but sometimes even states, they say, okay, this, I do this, but it is not because I accept that it is a legal fact, but because of some other considerations. This is one question. And second question, if possible, to propose a case study, small one, Palestine. Like, is it a state? And what about the effective government there? Thank you very much.
Okay, so yeah, this is of course very much at the core of people's concerns. So in the first instance, I would say that the basic principle about collective opinio juris as the touchstone of the acknowledgement of either the package of rights, obligations, powers, and immunities belonging to the entity, or the assertion of those by the institution that purports to represent the entity, that both the state and the government, that those are basically the same conceptually. So we're going to be looking in the international system, I would argue, for these manifestations of opinio juris. Again, most people don't conceptualize it this way. Most people assert that recognition is merely declaratory, and they assert that there are these rules that govern these questions. The problem is that history doesn't back them up on that the rules really don't predict how states will make legal judgments about these matters. And therefore, I think we need to look to collective opinio juris as the answer. Now, in terms of how do we discern it? Well, it's hard. So in terms of statehood, for example, one of the issues that I've had to grapple with over a long period of time is Taiwan a state? And how would we know? There is no question that if the Montevideo criteria were actually the criteria of statehood, and therefore we have the declaratory theory, it's simply if statehood is objective, whether we recognize it or not is immaterial, then Taiwan would clearly be a state. There's really no argument to be made about that. There's an asterisk to this having to do with a certain kind of assertion that James Crawford notoriously made about Taiwan not having directly asserted their independence. But everybody understands that they didn't assert their independence because they would be attacked. I think that they're basically it's reading into the Montevideo criteria something that's sort of mischievous in order to avoid the clear result. So the question is, how would we know if Taiwan is a state? It's not enough to look at the objective criteria. We would have to see how states interact with Taiwan, and the answer is really quite equivocal. The United States, notwithstanding its strategic ambiguity on the question of Taiwan's status, acts as though Taiwan is a state effectively because it provides security assistance to Taiwan in a way that would be incompatible with international legal obligations if this were otherwise. You can't provide military aid to a breakaway province of a foreign sovereign state. And so the United States and Japan and some other states that have provided or sold military equipment to the Taiwanese would seemingly be manifesting a sense that it actually is a separate entity, even though they refrain in their recognition practices in terms of declarations of recognition from making a political acknowledgement of Taiwan's status. But it's very complicated. There are all sorts of different areas of law which seem to cut in different directions in all of this. And I think that there's in some way, at the end of the day, no real answer to the question of whether Taiwan is a state because the indicators point in different directions. And so that's a sort of problem we have generally. Similarly, with respect to recognition of governments, that sometimes we'll know because, for example, the state assets will be given over to a government that is not the effective government, and then we will have a sense of what the legal judgment was. But most states in the international community are not in a position where the question is squarely posed to them. Questions about diplomatic immunity operate in this way, and not with respect to ambassadors whose credentials have to be accepted or not, but with respect to foreign ministers or someone like this. Someone is sought to be arrested in your airport. You find that you have to make a legal judgment. Is this person a foreign minister of an established government that has standing in the international system to assert the state's immunities? That's a question that's thrust upon a state at a given moment. But the circumstances are episodic, and so in some cases it's going to be very difficult to come to a clear conclusion about what the position of the international community is about the status of either the entity itself or the institution that represents the entity. With respect to Palestine, Palestine, of course, has recognitions now from something like 140 states in the international system. It does not fulfill the Montevideo criteria, but lots of states have been recognized without fulfilling it. If you look back to the decolonization era, Angola was recognized as a state in 1975, even though there were armed forces of three different movements that controlled different parts of Angolan territory at the time of Angolan independence. And this is the case in all sorts of circumstances. In the dissolution of Yugoslavia, Croatia and Bosnia were recognized as states, notwithstanding the fact that they did not control substantial swaths of their territory. The doctrine of self-determination tends in the direction of saying that a state exists, when the international system decides that it ought to. And if the international system has conferred upon a particular territorial population the status of peoplehood, which it actually withholds most of the time, but it has conferred that on the Palestinians officially since 1974. Then there's a much stronger sense that the conditions for statehood can crystallize, notwithstanding the failure of effective control on the ground. And for many legal purposes, of course, Palestine is considered to be a state, including for the International Criminal Court, which exercises jurisdiction over the territory of Palestine to the extent of indicting the prime minister and the former defense minister of Israel for acts that had direct effects within the territory of Palestine, not controlled by the Palestinian government. So, my bottom line in that is that Palestine is a state, but of course, there's still room for people to contest the question.
Thank you very much. If there is no other questions, no. Okay. Thank you, Professor, very much for interesting and informative presentation. And thank you for supporting first Jessup School, Summer School in Armenia. I truly appreciate it and hope to welcome you to Armenia soon. Maybe we will talk about it later. So thank you once again and goodbye.
Thank you all, and I'll send you a link. Take care.
Thank you. Bye.
Bye-bye.